Welcome to everyone. Thank you for coming along today for this webinar, the Local Authority Forum webinar, one of my favourites, sponsored by Geodesys, and I'm delighted to say that my dear friend Kay Toon is with us today. Hi Kay, lovely to see you.
Hello, hi everybody.
Thanks for joining us. Great news. What we're going to do this morning is we're going to look at some topics that I think are relevant to you as local authority lawyers. Remember, it is a forum, so you're more than welcome to put into the chat any questions or queries you've got, any sort of burdens that you're currently encountering as property lawyers, and between Kay and I will endeavour to assist or put it open to the forum to allow other attendees to explain their view or their position. So anything you want to talk about, put in the chat. I've got some topics to talk about, but before I do that, Kay, it would be a real delight if you could just share with us the work that you're doing at Geodesys, to share with attendees the services that you can provide to local authorities. So if I may, Kay, I will stay in charge of the slides and move them as and when you direct, but over to you for a little while.
Perfect. If you move on to the next slide, please. Right, morning everybody. I know a few of you on this call because we have so many local authorities utilise this service, and this is our concierge service, which I just wanted to do a little bit of deeper dive into and just explain what the service is about. Now, this is our concierge team, and between us, we've got over 30 years of experience in the conveyancing industry. So we have full understanding of your needs and requirement, particularly with local authorities as well. We have the ability to map large, very complex sites, land very quickly and easy because we're mapping data experts. Any orders or emails we receive within the concierge team, we process within 3 hours of receipt. Whether that will remain the same with the SDLT coming up, I don't know, but we've not seen too much of a rush on that. And as I said, a lot of local authorities use this service, and I should have put it on the slide, but to be honest, I forgot. But we did a customer survey in December, and 100% of local authorities said they would recommend us for this service. Next slide, please, Ian. So what is our concierge service? Basically, we do everything for you, and the benefits to you as we're mapping and processing any quotes, orders, we know our data suppliers. So we have the ability to identify any errors which our suppliers will query. So we'll query them first, so it saves any delays, and the quicker turnaround time really helps you. So our team is like really proactive. We chase searches, so you're not having to constantly chase anything. And the best thing is, because we do it in-house, you kind of would outsource your searches. There's no training for you to go through. Next slide, please, Ian. Oh, and one major thing, it's totally free of charge. So let's talk about the order process, how easy it is. In fact, can you go on to the next slide, please, Ian? I'll demonstrate. So this is an email template. You would simply just email concierge@geodesys.com. You'd put in your matter reference, the address, note whether it's residential or commercial. Always attach a plan of the area you would require. Type in the searches required, or if you've got a specific search pack, just state that. Any additional searches required, so utilities, highways, chancel, or any part 2 questions, just simply send that email. We'll map it out, send the quotation back to you, including a new boundary, and wait for you to get your client's approval, And then once you've got it, just send us an email and we'll order it all for you. All is you have to do is wait for the searches to arrive, or you can track it through the dashboard on our website and download anything that's returned. So it's really, really quick and easy to use. And what we can do as well is, if you're not already using us, is just simply set you up with an account and we can invoice you how you require. So weekly, monthly, however your accounts department works. Next slide, please, Ian. So these are the webinars that we've got coming up in February and March. So please always look at our website for the next events. It's always great to see local authorities, and no doubt we will be doing more specific local authority forums with Ian at IQ and the team at IQ. And if anybody's interested, what I can do is send the YouTube videos of the is it 3 or 4 local authority forums we've done now, Ian?
I think it's 4.
Yeah, I'm more than happy to send the link to those out so you can share with the team. One last slide before I go. Can you just go on to, thank you.
Yeah.
I want to talk to you about this service. It's nothing to do with conveyancing, but it's, I suppose I'm asking for your help if you could pass it on to somebody. This is called In Your Area, and it's mapping data that utilities companies use at the moment. But we've had at various exhibitions, local authorities express serious interest in this. What does it do? It enables you to deliver excellent customer service by keeping customers informed of any incidents that's happening in your area. So, for instance, it could be fallen trees, potholes, roadworks. So the modules that's down the side, they're based for utilities, but what's ever important for local authorities, we could put this on your website and you could notify potential customers of any incidents. They could log onto your website and see, which gives your website good traffic. And you can also notify customers of any incidents who sign up for the service via SMS. So it's a really unique service. So it would be good if you could think of anybody within your local authority who would be interested in that. And then here's my contact details, and that's all from me. I will say I will be sending the video and the slides out some point this week, so you will have all the information as well. Over to you, Ian. Thank you.
Thanks, Kate. Kate, just before you go there, this in your is this a Geodesys sort of idea? This in your area?
Yeah. It's right. Because obviously we're a part of Anglian Water. We are mapping experts as well, and we provide this service to utility companies, and it's crucial for those to how they work. But as I say, at an exhibition, so many local authorities expressed interest, and I thought, well, it's on a local authority forum, it's good just to shout out about it.
Well, tomorrow I'm spending all day with the Institute of Highway Engineers. They're sort of legal person to go to, so I do training for them, and this would be really valuable for them with regard to road closures, etc. You know, if, like you were saying, a fallen tree across a major road, something like that is a fantastic resource. And as you say, for a local authority to have the facility is brilliant. And if nothing else, it'll drive traffic to the local authority website, and it's a service, isn't it? Okay, for the members of the public in the local authority area.
Yeah.
So win-win.
It's just about delivering excellent customer service.
Yeah. Case contact details are on there. And again, from a local authority perspective, it's important to understand and appreciate just how useful Geodesys Kay and the team can be. So, if you are buying a site or you're swapping a bit of land, so a developer is saying, well, we'll buy that bit of land from you, but we'll give you a bit of our land in exchange, etc. The need for searches is important. The facility to be able to do searches is important. And this concierge service, Kay, it seems to me, is perfect on the basis that I just fill that form in that you showed me, and away we go. I don't have to worry about it till the search results come back. So, Kate, are you happy, if anyone's interested, to do a sort of virtual demonstration for people?
100%, yeah, more than happy to do that.
Fantastic. All right, brilliant. All right, thanks very much for that, Kay. That was really interesting, and appreciate your help and your time. Okay, topics. First thing, and Kay and I were looking at this and talking about this a little earlier. New housing targets. Where on earth? Oh yeah, it was I think it was Cornwall yesterday, Kay. I was listening on the radio, and they were saying in the past their housing targets were something like 500 new homes, and their current target is 4,000 new homes. And what they were saying is a massive problem in finding 4,000 sites, plots. But the other issue they were saying is no way in Cornwall have we got the craftsmen, the workmen, etc., to be able to build the number of houses we're being asked. So I think, is anyone finding this an issue? Is anyone sort of being proactive as a local authority and say, hey, we can do this? I'm really interested. I think you are as well, Kay, to see just what people are doing with regard to housing targets. So anyone and talking to estates teams or strategic teams within your authority, and if you could just feed back as to what's happening with regard to new build plots, that would be really interesting. So, Kay, I think we'll monitor the chat and see what people have to say about that, because that's good. Well, Kay, what have you experienced? Have you had any local authorities talking to you about it, or are you as an organisation seeing this as a major issue, or what's your view or take?
To be honest, we have had a lot of local authorities. So if a developer's buying or building a residential site, we have had a lot of local authorities say buying 10, 15, 20 houses within that development site. Right. So we are having a lot of that as well. Guys, as Ian mentioned, this is like a forum, so please feel free to tap any questions in the chat or the questions and answers, so Ian can answer them. Yeah, and you can help, Kay. You can help with Anyway, right, okay. So while we're waiting for people to put things in the chat, I've got some questions and some issues and some help to provide people. First of all, over the last 3 months, I've had lots of people talking to me about the land registration gap, the issue arising with regard to management between legal completion of a purchase and registration of the new buyer as registered proprietor. So I'm getting loads of people saying to me, Ian, what's the position? If I have completed the purchase of an office block, but I'm not yet registered as proprietor of that office block, am I the landlord or am I not? So if there's commercial management issues arising with regard to that property, who's the landlord? Well, there's loads of case law on this, but in short and put simply, the seller remains the landlord until you're registered as proprietor. Okay, now there are cases that are of exactly the same issue in connection with residential property, and again the same general principle applies, except every now and again you'll see a tribunal decision that will say, well, the buyer is the de facto landlord, and for our purposes therefore will allow the buyer, even though not registered as proprietor, to participate in management issues. Has anyone encountered that as a problem? Okay, so you've got the problem with regard to the gap between
completion and registration in a straightforward transaction. And I was talking to someone about this last week, and they were saying the registration process on registered land was taking nearly 12 weeks, and there were management issues arising with regard to a commercial block in that intervening period. And then, of course, you've got the bigger issue with regard to unregistered land being subject to first registration, and then you've got the huge delays, haven't you, between completing and the land registry getting their act together and registering. So anyone encountered any problems with regard to that? It is a problem. Hot tip: if you go on the City of London Law Society's website, I'll just put this in the chat. If you go on the City of London Law Society's website, and it doesn't cost anything to do this, and look at the Land Law Subcommittee, on that site there is now wording that you can put into contracts so that the parties agree what is to happen with regard to management. And either the buyer becomes the seller's agent in connection with management issues, or the seller as proprietor does what the buyer wants to do with regard to commercial management pending registration. Has anyone seen that? Has anyone looked at that website, by the way? It's really interesting. There's some really interesting stuff on there. Louise, Neil, Simon, anyone looked at it? There's a precedent form of report on title in commercial transactions. There's wording for rent deposit deeds, certificates of title, clauses for commercial leases. There's all sorts sitting there that you can utilize. Really, really valuable. But the registration gap issue has, to an extent, being resolved by this wording that you can use. The other point about that is I'm dealing with a title insurer at the moment that's looking at producing a product that will ensure an application for first registration. In other words, if you're buying from a property that's currently in the throes of being registered, you can take out an insurance policy, hopefully, that will protect you in the event that the title isn't ultimately registered or isn't ultimately registered with an absolute title. The last point, really, with regard to the registration gap, again, think about voluntary registration. The Land Registry years ago had a real sort of thrust with local authorities and local authority land banks and saying, look, we'll voluntarily register your titles. And I think most local authorities took up that offer. But if you are dealing with a piece of land that is currently unregistered, do think about voluntary registration, on the basis that voluntary registration will mean that by the time we're coming to deal with the land, it is in fact registered. Someone said to me that there are major problems with regard to unregistered development sites and residential buyers buying plots on those unregistered development sites, and issues with regard to the registration process being sort of overtaking the conveyancing process with regard to residential properties. Just flowing on from what Kay was saying a little earlier, is anyone finding that as a local authority, in order to meet housing targets, that you're buying building plots from developers? So Neil, anybody else encountering issues with that? So your estates team or your strategic teams are saying, look, we're buying resi properties in order to try and meet the need or fulfill our duties. Okay, next thing I've got is this case of Mesonex Property Investments Limited against Lanark Square. Have you seen this one? Really interesting commercial case where landlord was asked for consent to alterations. Just going to pull it up on my other screen because it's a really interesting case that I want to spend some time taking you through. But I think it's really useful to give you a flavour as to how the courts will deal with applications for landlord's consent. So I'm just pulling it up on my other screen and I'll just take you through the case if that's possible. The first thing with regard to this case was that you had a position where the court was asked to consider the stance of the landlord when an application was made for a landlord's consent for alterations. And the position was that the consent was being withheld rather than a refusal. And the withholding of consent lasted right up until the date proceedings were commenced. So again, what we had was a mixed-use building. Landlord was freehold owner of a wider estate and also an intermediate leaseholder of one of the buildings within that estate. So quite a big scheme, quite a large series of properties within the scheme. The lease that was subject to the dispute contained a covenant against overloading the floors, roofs, or structure in any manner which would cause undue strain, not influence, or interference. The tenant wanted to add 3 floors to the building to create 9 flats and to convert ground floor offices into residential units. Again, not uncommon sort of activity. One of the things I'm doing a lot of work on at the moment is airspace and rooftop development. And again, planners are sort of encouraging airspace development or repurposing commercial buildings. So we're seeing a lot of this type of alteration work or development work being undertaken. Okay, so tenant writes to landlord and says, can I have your consent for the rooftop works and for the ground floor works? The request was made by email in May 2020 and June 2020. Landlord says to the tenant, look, before I make any decisions about this, I need more info. It would need to have preliminary drawings to be submitted. It would need final architectural and structural working drawings. It would need a complete set of drawings for the entirety of the work to be submitted 6 weeks prior to the completion of the works. So the tenant goes scurrying off and gets undertakings for legal and some of the work, and landlord then says, I want undertakings for legal, architect, surveyor's fees, and the wording of draft licenses was subject to debate and discussion. Okay, December 21, all major issues seem to have been agreed. In February 22, landlord sought structural engineers' drawings for the rooftop works, and the tenant said, I'll get it. Okay, so early May 2022, we are still not in a position to say consent has been granted, but engrossed licenses had been prepared and had been signed for both sets of works. So we're plodding along, but we're taking our time. Then what arose was a problem concerning the proposed use of a basement car parking spaces as a site compound. And landlord says, well, hang on, we haven't discussed that. You need a separate license. Tenant says, we'll give you additional undertakings with regard to costs associated with the license for that. Landlord says, I'm not happy with that. Tenant then spits his dummy out and says, I'm not prepared to pay outstanding service charges as a precondition to completion of the outstanding licenses. So March 2023, we go skipping off to court. And the court says we've got to consider, surprise, surprise, Section 19.2 of the Landlord Tenant Act 1927, which implies a proviso that consents to improvement will not be unreasonably withheld or delayed. Remember, it was agreed that both the rooftop and groundworks were improvements for the purposes of the 27 Act. No argument about that. The argument really was, has there been an unreasonable delay? The High Court had a look at this and accepted that the tenant's requests were basically continuing requests, and it was necessary for the court then to consider the nature and scope of which the court should determine by reference to the circumstances and information provided up to the issue of proceedings, whether the landlord had behaved reasonably or not. Remember, the landlord's reasons must be those relied upon to be identified via subjective inquiry as to what was in the landlord's mind. So first of all, Mr. Landlord, what were you thinking about? Test 1. Test 2, whether those reasons were reasonable. And that's an objective inquiry, okay? The landlord was required to demonstrate its refusal was reasonable not that all its reasons were reasonable. That's an interesting point as well, isn't it? It sort of gives clarity to how these issues need to be decided. Tenant says he'd been asked to provide structural engineers' drawings for the rooftop works, but had failed to do so. The structural integrity of the building, the court said, was a reasonable, legitimate concern for the landlord. And it was reasonable for the landlord to treat the rooftop works and the ground floor works as one, because the court said this is a package of works that are dependent on one another. Okay, so a failure to provide drawings, etc., relevant to the rooftop would also be a reasonable reason for the landlord not to permit or consent to the works relating to the ground floor. The works that were being proposed constituted a trespass on the landlord's property. And again, in those circumstances, that had the makings of being unreasonable and being a reasonable ground to refuse as a consequence. It was not unreasonable for the landlord to consider the effect of the works on its adjoining property. There were issues associated with additional rights that pertained to that additional work that needed to be resolved, said the court. The other things that the court said was that there'd been no evidence provided by the tenant to allocate costs between the proposed works and the additional works that were required. The tenant had provided unconditional cost undertakings at various stages, but hadn't suggested that the sums requested were unreasonable. Lack of clarity for the tenant was unreasonable. The judge then asked himself whether the landlord's decision to withhold consent was reasonable, and concluded that it was, particularly given the structural nature of the work that was required. Really interesting case. If you haven't seen it, have a look at it. The reason I like it is it shows the hoops that the tenant must go through, and it also shows what a landlord has to do in order to behave reasonably. So I'm going to ask everyone attending today, have you all seen that case? If you haven't, I've done a case report in my magazine Property Law UK. I'm happy to share that with people. Okay, next thing that I've got on my list is modification of restrictive covenants in a case called Beecher's Capital against Hunt. Recent case. Has anyone seen it? This was a restrictive covenant imposed on some agricultural buildings that, put simply, prevented development of the buildings that increased the height of the buildings. There was land adjoining the farmland where the agricultural buildings were located that derived benefit from the covenant. The owner of the land that was burdened by the covenant made application under Section 84 to the Land Tribunal for variation of the covenant to enable the owner of the land on which the buildings sat to increase the height of the buildings. The idea behind that is that he wanted to convert agricultural buildings into some sort of visitor centre. So architects' drawings, etc., had been obtained for that purpose. Okay, so the owner of the land that was burdened by the covenant goes skipping off to the Land Tribunal to say, in the Section 84, I want these covenants removing. The covenants were dated 1959, and the first point I want to talk about is restrictive covenants generally. Very important when you're looking at a restrictive covenant on a registered title, or indeed in registered deeds and documents, is to not assume that the covenant is automatically enforceable. The first thing to do is to assess enforceability, and one of the key points is there land in the vicinity that derives benefit from the covenant, and is that land clearly identifiable? We all, I think, get lulled into the issue of, is the burdened land identifiable? But one of the things that's important from an enforcement perspective is the land that benefits from the covenant identifiable? The next point, really, with regard to enforceability is whether or not the owner of the land that has the benefit of the covenant has reacted when they've become aware of an application being submitted. That wasn't pertinent to this case. So we had, in essence, a wish to redevelop agricultural buildings and the owner of the adjoining land saying, no, what you're proposing to do, I'm going to object to. It's not a reasonable use of the land. If you are successful in having the covenant varied or removed, enabling you to redevelop these buildings, that's going to impact on an agricultural area within natural landscape. It's going to be visually intrusive, and it's going to generate light pollution and lead to an intensification of business use. So could the restrictive covenant be removed or varied? Tribunal says you definitely can't remove it. Okay. Matter goes on appeal to upper tribunal, and the upper tribunal said, well, all right, the redevelopment scheme is a reasonable use of the land, okay, and that use of the land is impeded by the current restriction. So the idea is that, you know, what you're proposing to do is not unreasonable. What we're concerned with is the additional height of the redeveloped buildings. The tribunal said, well, there's a security fence between the buildings and the land that has the benefit of the covenant. But the position was that that fence didn't really obliterate the view or do anything to mitigate the potential detriment that would arise courtesy of the proposed development. What the tribunal said is, we're not going to remove the covenant, we're going to modify it, okay? We're going to allow you to build your sort of visitor centre, okay? We're going to allow you to increase the height of some of the buildings. In doing that, what the tribunal said was quite interesting. They said that if we allow modification, one, we're not creating a precedent that means lots of other restrictive covenants within the vicinity are going to be subject to the same variation. Interesting point. Secondly, the position was that if the buildings were heightened, as a matter of fact, there were trees and a hedge and a security fence between the two parcels of land, meaning that the increased height wouldn't be particularly obtrusive. And the interesting thing was, the tribunal said we're going to allow modification, but we're going to pay or compel the applicant to pay to the objector compensation. What was the level of compensation that was awarded? £15,000. How was that arrived at? Well, what the tribunal said was there was loss of amenity that was temporary. When the hedge was mature, when the trees were mature that provided screening, there would be no real loss of amenity. So what the tribunal said is that there will be some loss of amenity for a period of time. £15,000, an appropriate sum to cover that loss. So really interesting case concerning modification of restrictive covenants. In that case, I think there's some key lessons to be learned. One, the parties need to behave reasonably. In this case, the owner of the land that had the benefit of the covenant objected, but then the parties attempted to reach some form of accommodation. And the tribunal latched onto that and said, well, all right, some development possible, some heightening of roofs possible, but let's look at what can be done in order to mitigate the effect of that with regard to a neighbouring landowner. There's a few other things I want to talk about with regard to restrictive covenants before I go any further. One, just because a restrictive covenant is protected by notice in the charges register of a registered title does not mean the restrictive covenant is enforceable. Number two, if you're a local authority and you impose a restrictive covenant on land that you're selling, it is essential that your estate team is aware of what could happen that could prevent enforcement action being taken in the future. So, in circumstances where you as a local authority are aware that a planning application has been submitted in connection with land that you've sold that's burdened by a covenant precluding development. If you fail to wake up and challenge what's being done, the obtaining of planning permission could be a problem. An awareness that the land is being developed, so advertising, services being put into a site, groundwork investigation being done, your estates department is aware of it but doesn't do anything to challenge it, could be a problem. Again, the estates team need to understand, one, that it may be possible to vary or remove restrictive covenant by way of application under Section 84, like we saw in Beecher's Capital against Hunt. So a restrictive covenant isn't necessarily a permanent restriction on development and use of land. Acquiescence, delay, estoppel can all prevent enforcement action. Now, important point flowing from that. In those circumstances, you're probably going to lose the right to get an injunction. You are probably going to be still entitled to claim damages for breach of restrictive covenant. The problem with a claim for damages for breach of restrictive covenant is that a court is unlikely to give you a share in the uplift in value of the land that has now been developed in breach of covenant. It seems to me, looking at court cases, recent court cases, that ship has sailed. What the court is likely to do is to say your damages are the diminution in value to your land, the land that benefits from the covenant. So do be careful if you're thinking, well, there's been a breach of covenant, we can get an injunction, because at the end of the day, probably the injunction is the remedy that you want. Delay can prevent an injunction being awarded by the court. Unreasonable conduct could prevent an injunction from being ordered by the court. Acquiescence or an estoppel can have the same effect. So you and your estates team need to be on that, okay? The slightest hint of development on a site that's burdened by a restrictive covenant, or the slightest hint of breach of covenant, triggers a reaction. And as far as that action is concerned, it would be desist or we bring proceedings. Okay? As far as the proceedings are concerned, remember, a court always has a discretion as to whether to grant an injunction. Striking quickly and early on where there's a hint of development has got to be the better course rather than sitting back and waiting and seeing. The other point with regard to restrictive covenants is, again, be aware that you may be approached on the basis that is it possible to buy out the covenant? And again, when looking at what would be a reasonable sum to buy out a restrictive covenant, you might be looking at the sort of Rotham Park sort of damages or compensation or value. So, you know, yes, we'll release the covenant that prevents development, but we want a third of the uplift in value of the land that's being released. I think there's an argument that those sort of days have gone. And again, the amount would be the diminution in value of your retained land. Anyone had any issues with regard to restrictive covenants? If you ever need a barrister to deal with issues concerning restrictive covenant, there's a great guy called Christopher Heather who's at Tanfield Chambers. Really good guy, very, very switched on with regard to restrictive covenants and enforceability. Again, do you all have relationships with sets of chambers? Anybody? So Louise, Amit, anybody else? Do you have sort of relationships with council up and down the countryside? If you don't, council these days, barristers' chambers these days are very keen to develop relationships with local authority legal departments, conveyancing teams, commercial property teams, etc. So again, useful sort of contacts. And some sets of chambers, Landmark Chambers in particular, Falcon Chambers in particular, Tanfield, Maitland Chambers, all have loads of resources that you can tap into free of charge. So Tanfield Chambers, for example, has a hub with regard to Building Safety Act, as does Falcon Chambers. Really useful to get information and get advice, as it were, on the cheap. Which leads me to the Building Safety Act 2022 and issues for commercial property lawyers. Very important point. One, the Grenfell Tower inquiry report highlighted the fact that the inquiry was of the view that the definition of higher risk buildings is arbitrary. So remember, a higher risk building, a building more than 18 meters in height or more than 7 stories in height that contains at least 2 residential units. Note I say residential units, not residential dwellings. Okay, so if you as a local authority are landlord of a building that's more than 18 meters in height or more than 7 stories in height that contains 2 residential units, that is a higher risk building for the purposes of the Building Safety Act. So if you had a building that's exclusively commercial with 2 caretakers flats in that building, that's a higher risk building. Now, what the inquiry said was we shouldn't be looking at height or stories to determine whether a building is a higher risk building or not. Surely there are other factors, such as the construction of the building, means of escape from the building, the age and status and health of occupants of the building should all be factors. So I think the government at some point in the near to medium future is going to turn around and say the concept of a higher risk building shouldn't just be determined by height. And that could mean that all of a sudden buildings that you've got within your portfolio or within your local authority or county council's ownership all of a sudden become higher risk buildings. And you're going to say to me, well, Ian, does it matter? Well, bet your life it matters. If a building is designated a higher risk building, 1, it's got to be registered with a building safety regulator. 2, it's got to have imposed on the landlord or building owner additional duties, burdens and responsibilities with regard to building safety, which are extremely onerous. And 3, if there are residential leases, long leases within that building, those residential long leases now have implied terms. The next thing with regard to the Building Safety Act is you could have a situation where your client or your local authority owns a building, but then intends to undertake airspace development, like in that Mesonex property investments case that we just looked at. Okay, so you might have a building currently that doesn't meet the height or story criteria to be a higher risk building, but because of development, it does. And the last thing with regard to the Building Safety Act that I want you to understand and appreciate is this. If you're a commercial tenant in a building that's a mixed use building and you're a tenant in a higher risk building, the Building Safety Act has implications for you as a commercial tenant. 1, if you're carrying out alterations, and I go back to Mesonex again, if you're carrying out those alterations, you need the consent of the building safety regulator as well as the landlord for the works that you're doing. Number 2, the works that you're doing could mean that you become a higher risk building, could mean that you become a relevant building. And if you're a tenant in such a building, the Building Safety Act provides you with some protection. So let me just give you an example, okay? You as a local authority have rented office space on the first floor of a building that exceeds 5 stories in height and is more than 11 meters in height, but isn't a higher risk building. For the purposes of the Building Safety Act, that building becomes a relevant building to which the Building Safety Act applies. If you're a commercial tenant in that building, the Building Safety Act gives you some protection from service charge costs. Notably, under Part 2 of Schedule 8 of the Building Safety Act, the landlord cannot transmit into your commercial service charge the cost of remediation of defects arising from works that the landlord or an associate of the landlord undertook in the first place. So you need to be aware of the application of the Building Safety Act. It is far more extensive than simply applying to residential long leaseholders. It has implications for all different types of commercial property. Anyone had any BSA related issues or problems? Anyone managing a building that contains residential long leaseholders? In those circumstances, both the Part 4 and Part 5 of the Building Safety Act and remediation and service charge issues are going to apply to that building and to those tenants and leaseholders. The next case I mention is Social Money Limited against Atwell Solicitors, where Atwell Solicitors, acting on behalf of a lender, gave a series of undertakings to the lender's solicitors, and an application for summary judgment was applied by the lender against the solicitors for breaches of undertaking. And it's a really interesting case because it shows the danger of giving vague or ambiguous undertakings. Be clear about undertakings that you as a local authority lawyer are giving on behalf of your local authority. Anything that's vague or ambiguous will be construed against you. Again, look at the wording of the undertaking. In that case, one of the things the court was looking at was an undertaking that would be impossible to perform. And the argument there is such an undertaking enforceable? And the court seemed to be saying, man, it was only on summary judgment, was saying no. So really interesting case. Anyone's interested in having a look at the case, I can send you the citation for it. And the last thing that I want to talk about are boundaries and adverse possession. Handy Cross Developments Limited and Value Properties Limited was a boundary dispute concerning a property developer and the landlord of a Hilton hotel. And the issue and the problem arose in that when the two parcels of land was split and a boundary was created, the boundary hadn't been defined. And therefore the court was left with a position where the parties had sort of coexisted for quite a while, and the court was left to try and determine where the legal boundary sat between the two titles. Whenever you are creating a new boundary, whenever you are buying a site, boundary identification is so important. Boundary disputes notoriously expensive. So absolutely essential to make sure that boundaries are clearly identified. Where you're concerned about boundary sensitivity, you can make a determined boundary application to the Land Registry or enter into a formal boundary agreement. But this case just highlights how problematical boundary identification can be. The land registration system does not assist in enabling legal boundaries to be readily identifiable. Where a boundary isn't clearly described or clearly revealed on an appropriate plan, the court, in essence, is left with trying to determine what was intended when the boundary was created. And that can be difficult, if not impossible. So again, with regard to boundaries, I repeat, determined boundary applications are useful if parties are in agreement where a boundary sits. Formal boundary agreement achieves the same end. Really useful website for you. The site called Property Protocols, which is basically a commercial property related site created by lawyers. But on that site, there is a boundary dispute protocol. And this is really useful for a number of different reasons. One, if you are, as a local authority or council, involved in a boundary dispute, it shows you the process for dealing with the dispute. Two, it shows you the problems associated with legal boundary identification and also shows you the solutions, determined boundary application or formal boundary agreement. I'd have to say that bringing proceedings in connection with boundary disputes is a nightmare. Okay, an expensive nightmare and a high risk piece of litigation that I wouldn't encourage at all. So making sure that boundaries are clearly identifiable when land is being purchased or land being subdivided has to be sensible. Caution needs to be exercised. Determined boundary applications are brilliant where there's agreement and brilliant where you've got a properly produced plan that contains sufficient detail to enable the Land Registry to determine the boundary. There is an argument that formal boundary agreements are only binding as between the current parties and are not binding in connection with subsequent landowners. So that's something just to bear in mind and something just to be aware of. The last thing that I wanted to talk about today was adverse possession and problems associated with adverse possession. There is a case that was just heard in the Supreme Court on the 25th of January. We're waiting for judgment, where the argument that's been raging for a couple of years now will hopefully be determined by the Supreme Court, namely, where a neighbour is claiming adverse possession due to 10 years adverse possession. Remember, one of the grounds for making the claim is that they had a reasonable belief that the land belonged to them. And remember, there's been a whole raft of case law where the courts are saying, is it necessary for the application to be made within the 10-year period or on expiry of the 10-year period, the latter making the most sense? So you've got to have 10 years in which you reasonably believe that the land belonged to you, and then you'll make your application. Or the alternative view, you must have had a period of 10 years where you thought the land belonged to you, and then logically you realize that it doesn't, or someone else contends that it doesn't, and then you make your application. The problem with the first sort of basis of making an application is, why would you bring a claim for adverse possession if you had a reasonable belief that the land belonged to you? There's no need to make your application. And this was one of the things that was argued before the Supreme Court on the 25th of January. I think the case is called Brown against Root, but I'll dig it out. But it's really interesting, and I will be writing a report on it once we see the Supreme Court judgment. But do be careful with adverse possession claims. I have to tell you that local authorities are notorious for losing land due to adverse possession, through no fault of the local authority. It's just you've got large land banks and few resources to properly manage them. Where you are of the view that there is the potential for an adverse possession claim, what can you do? Well, one, regularize the position by granting some form of license or tenancy. Two, by bringing proceedings for trespass, which can be an expensive exercise. Three, by simply notifying the other side that you object to what they're doing and asking them to vacate. I was looking at something yesterday which was quite interesting, where someone was claiming adverse possession in connection with a grassed area, and what they'd done is put white stones or white rocks around the perimeter of the land that they were claiming adverse possession. And the argument there, well, there were two arguments. Argument number one, the grassed area was a verge that was part of the highway. And two, there's a section of the Highways Act that prevents people putting stones or obstructions on a grass verge. But again, with a situation like that, if you are contracted by the highway authority for grass cutting purposes on grass verge, then grass cutting schedules, etc., records of when grass has been cut, can be useful to oppose an adverse possession claim. And the last point I want to mention relating to adverse possession, are you aware that if you as a local authority lose land due to adverse possession, there is a process under the Land Registration Act that enables you to get your land back? So if you had a situation where you've lost a parcel of land due to adverse possession, and you then investigate the application, and you can determine, one, there was a procedural irregularity with regard to the application, or two, the adverse possessor has lied with regard to their statement of truth, stating that they've occupied the land on, you know, all the sort of detail that goes with it. If you can show that's not correct, then you can apply to the land registry for rectification to get your title back. Again, not many practitioners are aware of that opportunity. Last point with regard to adverse possession, if you ever receive an adverse possession claim as a legal department, always make sure that you object to the application, and be careful how you fill in the form that enables objection. There's a horror story where a firm of lawyers completed the form incorrectly and then lost their client's right to object to the application for adverse possession. All of that's contained in Schedule 6. No one so far has typed any messages for me in the chat box, so I feel rather lonely. Has anyone got any really burning issues? Anything they'd like to talk about? Remember what we said, first of all, new housing targets. Anybody had any problems or issues with it? Number two, anything, because we've only got 5 minutes left, anything anyone would like to talk about. Three, have my dronings and my ramblings on been useful? Four, is there anything you'd like to talk about next time? So I'm going to now just sort of fire away and see what people have to say. So Julie, Jane, Joanne, anybody, Andrew, Sally, lots of people in attendance. You must have some burning questions. How do we deal with our terrible colleagues in the estates department? That's an interesting question for next time, isn't it? Yeah. How do we deal with lunatic neighbouring landowners who ring us up and ask us difficult questions or impossible questions? Tell you what, here we are. Look at that, Kay. I knew someone would look at this right at the end. It always happens, Kay. Always happens. Just when I'm about to go for my lunch. Look at this. Michael. Hi, Michael. We have issues effectively high, but not adopted highwayland. Try to adverse possess it, prevent adjoining landowners encroaching. Well, I think there's an issue, Michael, about adverse possession on highway, first of all, isn't there? And the other point is, remember, as far as adopted highway is concerned, the verge might not be adopted, but could still be highway, couldn't it? Remember, if you have an opportunity to pass or repass on a grass verge adjoining the highway, it can be deemed to be highway. But Michael, if you send me an email about that, I'll have a look at it for you. Darcy, hi Darcy, dealing with this at the moment where the local authority has lost some land due to adverse possession. Good to know about the process for rectification to get the land back. Darcy, if you drop me a note, there's some case law that will support that for you, okay? So anyone, I mean, if you want to talk about highways, we can do it. Kay, how about this for boring, right? I once did a whole morning talking about drop curbs. So if you think the last hour's been boring, can you imagine talking about drop curbs for an entire morning, the law relating to drop curbs? Tomorrow, I'll be talking about the law all day relating to highways. It's really interesting, so I enjoy that. Simon, to take claim to be part of the adopted highway. Yes, Simon, often the highway authorities' maps are sort of unclear, and then therefore you're left with sort of common law principles, hedge-to-hedge type principles. But there is quite a bit of case law relating to that. Perhaps, Kay, next time we could talk about highway issues, electric vehicle charging on the public, on the road, this sort of thing. As I say, I'll do loads of stuff relating to that. But I think just about time has caught us up. So listen, isn't it funny, Kay, when I complain about being all alone and having to go back and sit in my little cupboard till next time, loads of people start firing things with regard to questions, which is great. Yeah, please talk to Kay about her concierge service. Please send me an email. I'm going to put my email address in the chat, and there's an email address there as well. But send me an email about anything you want to talk about, and we'll happily talk about it next time. Okay, any sort of final words?
No, just everybody, thank you for attending. I hope you found it useful. As I mentioned earlier, I will be sending all the slides and the video recording out at some point this week. So where you'll have myself and Ian's contact details. But thank you, Ian, and thank you all for attending.
Thanks, everyone. Really enjoyed it. Kay, as ever, brilliant. Speak soon. And good luck with the move, Kay. Good luck with the move.
Thank you.
Take care. Bye-bye, everyone. Bye-bye.